learning about business in a university and actually starting a business are two very different things, right?
What are the legal consequences for companies that fail to disclose the breaches in a timely manner?
Whoever collects the data is responsible for that data. In Canada, we don't have this distinction as they do in the European Union between the data collector and the data processor.
When we talk about cyber attacks, right, like what are the first steps from legal perspective?
They have to consent, right? And consent implies that they understand the risks associated with sharing that data, your customer behavior, which is really important for your business decision making. In the public sector, you're dealing with the Privacy Act at the federal level and what's known as the Freedom of Information and Protection of Privacy Act at the provincial level.
Hello everyone, welcome back to Learn Launch with Rajen, episode 16. In this episode, we have Rajen Akalu, who brings over 20 years of experience in digital transformation, privacy law, and policy. Rajen is also an executive member of Privacy and Access section of Ontario Bar Association, a voluntary professional association representing over 16,000 lawyers, judges, law teachers, and students across the province. So without any further delay, let's welcome Rajen. Welcome to the podcast, Rajen. It's great having you here.
Oh, thanks for having me.
So I want to start the conversation with an interesting survey from Shopify in 2024, where 93% of Gen Z individuals have started exploring the businesses. So while some businesses are successful, while some businesses will struggle. So according to you, what should they look into when they start a business?
Well, it's difficult for me to tell you how to start a business as such. But I think the main ingredients is having a client base or knowing who it is you're selling to. Right. So I think with any business is okay, what business are you in and what market are you serving? Right. That's very difficult. It's easy to say those things. Like in many things in business, actually, it's kind of easy to think of it conceptually, but actually doing it is a very different matter. And so, you have to think very, very carefully around what market you are in and what it is you're in fact offering, if that is a product or service.
Exactly. And also lawyers play an important role in these businesses. So according to you, at what point should companies start involving legal counsel, especially regarding the privacy?
Lawyers should be involved fairly early on in any business venture, typically, although it's one of these things where if you waited on a lawyer for everything, you'd never start anything. So you have to sort of, with any entrepreneur or venture, there's an element of risk, and you have to be able to accept that risk going forward. You will never have everything worked out, and you cannot control for all of the variables associated, all the things that can go wrong, and many things that go wrong when you start a business. Anytime involving a lawyer is prudent, and why? Because it can help you avoid many of the common mistakes, right? So the reason that you would involve a lawyer is you're trying to kind of avoid mistakes down the road. If your company is not set up well, it is a huge headache to then change it after the fact. It's going to cost you even more. I think of lawyers of two types. There are transactional lawyers. I would regard myself as a transactional lawyer. I help with the setup. I help with the compliance, and I help with contracts and privacy as well. But if a client goes to court because of one of my contracts, that's a fail for me, right? Another type of lawyer will now be involved, and that lawyer is a litigation lawyer. So we have the transactional type lawyers, and you have the litigation type lawyers. And the litigation lawyers are there dealing with a dispute. There'll be a plaintiff, there'll be a defendant, there'll be an argument over, let's say, the interpretation of the contract, or you didn't deliver what you said you would. You didn't perform on the contract, and therefore you are in breach, and now there's litigation around that, right? I think in terms of startup, it's very helpful for a business to speak with a lawyer that understands, okay, well, there are many different types of business. Yours is not necessarily unique. You should have a unique offering, but the legal structure underneath that will be pretty standard. But you have to know, have an understanding of the options available, and in order to move forward with any kind of confidence. And it helps you actually, because if you've connected with a lawyer and you understand what the contract is, you'll be able to better explain that to clients. So that's very valuable, especially if as your company becomes more valuable, the need for greater certainty, predictability in your business relations will require you to have more sophisticated advice involved.
True, exactly. And what are the consequences if we involve lawyers in between or maybe in the end? So is there any major consequences on that?
Well, it's hard to say. I mean, that's going to depend. It's going to
Uh-huh.
depend on the situation. It depends on whether or not the nature of the problem that you have, right? There are many do-it-yourself contracts now you can do. So almost anybody could go on ChatGPT and generate a contract now, right? But whether they understand the contents of that contract is another matter entirely. And you don't necessarily, it's not necessarily you have to become a lawyer, but you need to be able to understand how to explain your own contract, right? And oftentimes it's sort of the nature of business people as well. As I said before, you wouldn't wait on a lawyer's okay for everything, because if you're having to write a contract to deal with every possible scenario, it would be so expensive and in terms of the lawyer's time alone, but it wouldn't necessarily help you move your business forward, right? So any business is going to be dependent on its sales. It's a matter of judgment too, that you develop a skill. You need a lawyer, you need to instruct that lawyer well. And so one of the things I do now as a professor at the university is I help students with getting experience in instructing a lawyer, which is something that's very valuable, but you don't necessarily get the opportunity to do so well in the university context, right? But that's somehow very important when you are actually in business, because you won't necessarily need to know all the answers, but you do need to ask the right question. And so that's something that I've been very much involved in trying to develop in my own teaching and at the university too.
Yeah, and also you mentioned about ChatGPT, right? People can use it to generate privacy policies. So according to you, what is privacy law so critical for businesses or even the startups?
Pretty much all companies will deal with personal information at some level, right? And that's necessary and legitimate, because in order for you to issue a bill, you have to have the name and the customer address, personal information. So once you are dealing with personal information, you are almost certainly going to be subject to privacy legislation. So in Ontario, if you're a private sector company, the legislation that's going to be relevant is PIPEDA, which is the Personal Information Protection and Electronic Documents Act. And that sets out a number of different obligations that you now have as a business dealing with personal information. You've got to make sure the information you're collecting is limited, specific, you're open and transparent about your policy, your data handling practices, that you have safeguards, security safeguards in place, for example, to protect that data. Privacy is going to be almost certainly a necessary aspect of your compliance requirement in almost any business.
Since you mentioned about the Personal Information Protection and Electronic Documentation Act, it's for overall all the industries, right? Let's say financial, healthcare, on other industries. So it's like applied to all the industries, or like is it only for specific industries?
So in Canada, there is a sort of patchwork of different legislation, right? So if you're dealing with private sector commercial activity, then you're dealing with PIPEDA, the Personal Information Protection and Electronic Documents Act. If you are dealing with healthcare data in Ontario, the act that you are subject to is PHIPA, which is the Personal Health Information Privacy Act. And the reason for this difference is there are historical and constitutional reasons for this setup. As a general rule, property and civil rights are subject to provincial jurisdiction, but commercial activity has federal jurisdiction attached to it, right? And because the European Union made it a requirement that all the personal data of European Union citizens could not be shared with countries that didn't have adequate legal protection in place, that it was decided that Canada would have a federal rule, but allow provinces, if they wanted to have what's known as substantially similar legislation in place. So, for example, if you are in BC or Alberta or Quebec, they have their own provincial private sector legislation. So they don't look at PIPEDA, they look at their own provincial legislation. Whereas in Ontario, they don't have their own private sector provincial legislation. And they've been discussing the reform of this for some time. But as it stands now, if you are a private company in Ontario, you would be governed by PIPEDA. So that's for the private sector.
Mhm.
In the public sector, it's a little different, right? Because when you're dealing with, but you're not concerned with public sector data at all, but in the public sector, you're dealing with the Privacy Act at the federal level and
Mhm.
what's known as the Freedom of Information and Protection of Privacy Act at the provincial level. So let's say, for example, you want to find out about a government program. Those are the acts that you are going to be involved with there.
You mentioned about different provinces have these separate privacy policies, right? So what exactly they contain, the privacy policy?
Oh, in a privacy policy? So any privacy policy that a startup would have is going to have details around what data they're collecting, why they're collecting it, how they're using the data, and where to go if you have a complaint. And those are sort of the basic kind of parameters that will be in most privacy policies. And it's a legal requirement that you state your privacy policy on your website. That's why most websites will have that.
And what if, let's say, there is a privacy policy which mentions that we don't collect your data, but what if they collect? So what is these consequences that usually they face? Let's say in 2019, Google and Facebook were fined millions by EU regulators, right? Not because of these data breaches, but because of their non-transparent privacy policies that violated GDPR requirement. Coming to Canada, is there any situations like that?
Yeah, sure. I mean, you can be fined, for example. The Privacy Commission has the power to investigate your private data handling practices. They can take you to court, for example, in certain circumstances. And so, yeah, you want to kind of ensure that you are compliant to the extent it's not easy actually sometimes. But I also think of it as any company that's run well should know how data flows through its company. And the reason you want to know that is because in order for you to leverage that data, you need to know what it is, where it is, how it's stored. And the more a company is proficient at understanding the data it's collecting, using, and disclosing, the more it can make use of that data for actionable insights, right? You can maybe create new business opportunities as a result of that, or know, for example, your customer behavior, which is really important for your business decision making.
When we talk about these privacy policies, who will draft this? Is it lawyers or compliance officers? How will it work?
Typically, it's done by lawyers. There are many, many people that are privacy officers or privacy compliance people. But I mean, if you need an interpretation of the law, you need a lawyer to do that, right? I think there are many, many professionals that are involved in privacy law now, not just lawyers, there are accountants, there are privacy professionals that have a privacy certification, right? And it's a lucrative business. It's very kind of, lots of people involved in it, right? But I guess in order for you to understand what's in that document, right, it's helpful to have a lawyer, I think, involved in that, at least in the setup phase, right? If you're dealing with, let's say, responding to an access request or dealing with the data governance policy within an organization, then, a privacy officer will work well for that type of function. But I think that having a lawyer involved that will help you really understand what the terms mean. Right. And with privacy, it's super valuable because privacy is a really ambiguous term and it is really subject to personal interpretation. It's very easy to be subject to personal interpretation. And that's kind of fatal because whenever there is a dispute, they are going to assume that you know legal implications of the terms that you've used, right? Because you've drafted that document, right?
Is there any teams which are involved in privacy policies, like engineers, security teams, or even the marketing teams when privacy policy is drafted?
Right. When I've drafted privacy policies, I mean, you usually involve, you need to get input or information from various teams within the organization. Well, firstly, you need to know the data that's being collected. That's number one, right?
Mhm.
And then it's kind of like, is there a legitimate business purpose for each data element that is collected that you can justify and demonstrate? And then, it's a matter of judgment too, right? Because if you are a security person, you put down in your privacy policy all of the software that you use to safeguard the data, right? Well, the customer might not read that, but somebody who is a hacker is going to find that really interesting, right? And quite valuable. So that's ultimately an attack vector. So you got to think through the unintended consequences. So you've got to be. It's a balance between providing sufficient information that allows people to be assured that the data is being protected, but not necessarily, providing detailed schematics of your IT architecture.
Is there roles and responsibilities which are segregated around the team within those privacy policies as well?
Normally, a lawyer will kind of be able to coordinate most of that, to be honest, because it really depends on many privacy policies are fairly standard, although, they're going to be different nuances depending on the type of business that, being used. One of the key elements is whether or not the data is personal information, right? Because if it's not personal information, then it can be used without consent, right? And that's really important, right? Because so the rule is whenever you're collecting data from a user, they have to consent, right? And consent implies that they understand the risks associated with sharing that data, which is not necessarily true, but I mean, that's the idea, right? And that if you have another purpose for, you come up with another use for it, like let's say reselling it to somebody else, right? Then that has to be, you have to get a secondary consent for that, right? And lots of little things that maybe a lawyer will help you with drafting you might not even think of. For example, let's say, you want to sell your business, right? Well, if you didn't have a clause that allowed you to share the data with the prospective buyer, then you could potentially be in violation for that, right? So lots of little kind of nuances there that a lawyer can help you think through as you grow and develop your business.
Sharing that, Rajan. And also, how often should companies review and update their privacy policies, and what triggers unnecessary change?
So there isn't any legal requirement when you update. That's a matter of internal policy at a company. And I would recommend at least between 1 and 3 years to review the policy and update to make sure that it's consistent. Because ultimately, what matters is whether or not the statement is consistent with the actual practices of the organization. And sometimes what happens is that you put the statement out there and you don't review it, you don't think about it very much, and there's a misalignment to what is actually happening at the frontline staff, for example, right? So doing it at least once a year, or at least once every 3 years, right, would be advisable or recommended. And what types of things will trigger a update of the privacy policy? There will be two things. Either there's going to be a change in the law, or there'll be a change in the product or service delivered. So recent changes in the law for Quebec, for example, they made a new rule around biometric. Right? So if you're collecting biometrics and then you have to inform the Quebec Privacy Commission about that, and that's a new rule. So you are going to have to update your privacy policies based on that alone. If you are providing a different service, then you're collecting additional information, then you would want to review your privacy policy.
Got it. So we can say that our privacy policy is a living document, right? So it will update
Yeah,
based
sure, absolutely. It should grow with your company, and as you become more sophisticated, requirements that you will have. I mean, you're gonna have more customers, more potential complaints. You're gonna have to be able to respond to those complaints in a consistent way. Privacy policy is no different to any other types of policies that you will have to develop and implement as your company matures. So your privacy policy is a bit like a contract, not exactly, but a bit like a contract between you and the customer, right? And so since you've drafted it, you are held to it, right? And if it's drafted ambiguously or wrong, then, the customer is going to get the benefit of that, right? Because you drafted it, right? I mean, it's your document, right? So it's assumed that the person that drafts the document is going to draft it in their interest, and if it's ambiguous, that ambiguity is read in favor of the non-drafting party, so the customer in this case. So yeah, if your privacy policy is poorly drafted, it's not specific enough, I mean, it's not going to be enforceable, right? And then, it's going to cost you a lot more if it's litigated.
So, when we talk about cyber attacks, right? Like, what are the first steps from legal perspective?
The first step, so I mean, they're sort of the technical requirements, in order to, mitigate against the breach in response to, being notified of a breach or an access, unauthorized access. And then, contacting the lawyer is, if you have insurance, you contact your insurer. Insurer would direct you to a lawyer, and the lawyer then will usually require you to route all the communications through them. And the reason that they're going to want to do that is once you communicate with a lawyer and engage a lawyer, those communications are subject to privilege, right? That's one of the real big advantages of dealing with the lawyer, specifically in relation to privacy, because accountants can't offer that, right? Like other professionals won't be able to offer that, right? So once you retain a lawyer, you communicate with them, there is a potential for litigation. Those communications are not going to be, that are privileged, which means that nobody can get access to that. Privilege in relation to cybersecurity breaches is a tricky subject because you can only claim privilege around the strategy or the actions that were done or the communications that were made in anticipation of litigation. You cannot claim privilege over the underlying facts. That a breach happened on this day is a fact. You can't claim a privilege over that, right? Or if you have an internal IT team that had investigated the breach and are currently producing reports. It's part of their internal practice and therefore is regarded as a fact that is not subject to privilege. So what happens typically is the lawyer will retain outside IT forensic experts or IT security professionals, right, to go in and provide the report. Now, there's a debate around whether or not that's efficient because that's expensive. And the people that are internal to the company know the most about the actual system that they've been working on. And so, but unfortunately, if you want to gain the benefit of privilege and you don't want the other side to find out about that in a potential litigation, then that's what you would do. Now, an unclear question in this is the cost of litigation risk greater than or less than the operational risk associated with your system being down? Nobody really can, it's a very difficult question to answer, actually. That's one of the topics I'm kind of involved in my own research, trying to figure out, because making those decisions are very, very difficult in the moment. But that's typically, what's done by the lawyer. And then another key decision that the lawyer will help assist with is whether or not there is a requirement to notify either the Privacy Commission or the customer themselves. And that's based on the determination of what's known as real risk of significant harm. So there's a criteria that the lawyer will look at and determining, the sensitivity of the data, how the data was accessed, if it was unauthorized, if there was malicious intent, the sensitivity of the data. That will make a decision as to whether or not to notify. And that's a difficult decision, especially if a really large company and across different jurisdictions, they have different requirements.
You mentioned about notifying the clients, right? So there will be a time period, right? If there is a breach, clients has to notified within 24 hours or 48 hours.
No, not necessarily. So it's within a reasonable time, and that's not defined, right? So there's a judgment call there as to when to notify. And it's a difficult question, to be honest, because businesses don't necessarily want to be known for having breached their security. And this is why there are these mandatory reporting requirements in place. And then there is also a view that people are almost desensitized to notification now because it happens so often or it happens fairly regularly, and it's kind of meaningless when you get a notification. And so, but it's advantageous to usually get ahead of to inform the customer before something bad happens, which makes it much worse later on if there's an audit or an investigation as to your practices.
There will be a contingency planning, right?
Yeah, sure. So the larger the company, the greater the need for incident response planning, contingency planning, right? You need a plan because you don't necessarily want to make it up as you go along during a crisis, right? Which is the alternative, right? And so, when you're in a startup, that's not something you first think of, because when you're in a startup, you're just thinking about the next step, how do I get to the next thing? And that's, it's very stressful, very difficult, right? So, the idea, like, you almost have to have an optimistic bias when you start any business, because nobody starts a business thinking, oh, they're going to get a breach, right? But as the company matures, as the company gets bigger and there are more employees, more money involved, more staff involved, more moving parts, the need to have all kind of policies, not just incident response policies, are going to be greater. So having an incident response plan will help a company respond more effectively to a breach. Because if you have, one person, or, if it's a 1 or 2 person company, then it's not so big of a deal. But if you have 25 people in your company and the one person or 2 key people are away, then knowing who to contact and what to do next
True.
is going to be necessary. Then somebody else to draft that plan so that somebody not involved on the day-to-day can be able to follow it.
Exactly. And what are the legal consequences for companies that fail to disclose the breaches in a timely manner?
Oh, so they can be so that there's potentially a private right of action for class actions. Let's say there can be an investigation. There can be remediation. They can lose a lot of trust for their business too. Businesses like banks, they have to
Mhm.
have an incident response panel in place. That's a mandatory
Mhm.
requirement now, right? And so again, it depends on. Hospitals would be the same, right? So if you didn't follow a regulatory requirement, that is a big deal, right? Whereas if you're a startup, you have 2-3 people in your startup,
Mhm.
and you get a breach, there is, it's less, not to say it's the the negative is zero, right? But it
Mhm.
would be better if you had one in place than not.
And what legal protections or clauses should every company include in vendor or software contracts to safeguard the data?
So normally when you have a business, when you're starting a business, you will be um, working with other service providers. Now, large companies, what they do is they usually a vendor questionnaire of some kind, right?
Mhm.
Or an attestation form. Now, the rule is whoever collects the data is responsible for that data. In Canada, we don't have this distinction as they do in the European Union between the data collector and the data processor. The data collector is primarily responsible for that data. And their responsibility is to satisfy themselves that their third party vendor has adequate security in place. Because if you imagine, customer has no idea of what software you use, how their data is being processed, but they know you. They've shared the information with you. And so when you are making decisions around vendors, to onboard or to contract with third party vendors, if it's a large company, they will have, a questionnaire in place that goes through how, what security that vendor has in place. And then
Mhm.
that becomes part of the legal documentation. So
Mhm.
if there were a breach and there was litigation, the company would then still primarily be responsible. They would sue their service provider for failing for breach of their contract. That's how it usually works.
So when we talk about small businesses with limited resources, so what are the minimum legal privacy steps that they can take?
So if you go, Privacy Commission has a lot of really useful resources that are free, right? That will help you develop a privacy policy. That's kind of a better option, I think, than ChatGPT. So there are lots of free resources. It's like lots of things in a way in a business. If you can't afford it, you end up doing it yourself, and sometimes you do that badly. But that's just kind of how it goes. I'm always very sympathetic to businesses that come to me and say, look, this is what we did. Because I know how difficult it is. I know how
Mhm.
expensive it is. And I know that you can't afford to do everything perfectly. And you have to also accepting that it's going to change as well. And it's not like a once and done type of thing, right?
Mhm.
So yeah, if you were doing it on your own, I would look at, like, if I wasn't a lawyer and I was starting a business, I would go to the Privacy Commission's website
Mhm.
and look at their resources to figure out what steps I need to be put in place in order to at least have a sort of respectable privacy policy put together.
Yeah. So we're in the end of the podcast. Any final suggestions who want to get into businesses, start a
Yeah,
business?
you know what? Like, so I started on my website a a series of blogs called The Academic Entrepreneur because I know, like, it's very different learning about business in the university and actually starting a business are two very different things, right? And you have to sort of accept that it's very difficult, and that's not something that people really appreciate. It's like the idea of running a business, being your own boss, and having sort of, I don't know, infinite profit, right, is super attractive. But the reality is many businesses do fail. So the question is not necessarily whether or not you fail, it's whether or not you learn. Can you let go the idea that it has to be this way and adapt And they call it pivoting in business speak. There's a lot of terms like that, like being lean and being business, pivoting and, minimum viable product and all the rest of it, right? But when it comes down to it, it's a person trying something different that other people would not be prepared to do. And that can actually be very lonely in a way. You have to be prepared for that aspect of it too, right? And there's not very much help in that because you're supposed to be always grinding. It's kind of like there's the culture around it, right? Which I think is kind of pathological, to be honest. I think it's not so good. But on the opposite side, I don't think there's any better way of knowing who you are by kind of understanding your limitations. And you will almost certainly be confronted by your own limitations when you start a business. And the reason for that is you are not good at everything. I'm not good at everything, right? And in the process of starting a business, like I realized, okay, I'm good at this and I'm not good at that, right? Like I'm good at law, but I'm not good at accounting or marketing, right? And but that's okay because you can get other people. But if you know that, then you can get help with those things, right? So if you're not good at law, that's okay. You can find a lawyer that can help you with those things. But understanding your limitations is really key when you start a business, I think, because it helps you appreciate other people. And it also gives you a sense of what you can focus on, because you will have to have a lot of focus and a lot of discipline to start a business. The fact, and so it's very different from being an employee. It's taken me a long time to learn that actually myself, right? Because when you're an employee, everything is done for you. But I mean, somebody is in charge of your taxes, like little things like that, right? Like
Yeah,
you're not necessarily pricing your service. You don't have to collect and remit HST. You don't necessarily have to be, you're not responsible for corporate tax. If you take money out of the business, then income tax as well, right? You're not dealing with business development. You don't get paid to do that as an entrepreneur, right? And it can be very seductive almost to kind of have this idea that you are following your passion and you're kind of driven by this. And it's not that that's not important, because you have to be enthusiastic, otherwise you're not going to get out of bed, right? You also have to have a clear sense, going back to the beginning, of who is this for? How you define the market that you're serving, right? And that is an ongoing process that you will constantly be trying to refine in response to differences in market conditions. Because any lucrative market where there are high profit margins will be competitive, right? And you have to accept that, as part of the process. And it's not easy. It wasn't easy for me. It's still not easy for me, actually, I'll be honest. But if you sort of understand that, it's really helpful. And also know that I would say not everybody is going to understand your business like you. That's also a very difficult truth, I would say, right? Because there are going to be people that you thought supported you, were not really interested and are just along for the ride. That happens, right? And your ability to discern that, manage that, deal with people that want to kind of ride along for the ride, but are not necessarily involved, with your business. Or it becomes more difficult to relate to people that are employees actually in businesses, right? Because they are not dealing with the same types of problems that you are dealing with on a day-to-day basis, right? Like they're not, right? And that's also a challenge too, right? When I started my business, I put it up on LinkedIn. Like I started a law practice. I got several requests to if I was hiring, and I thought to myself, at home, hiring. I don't even know what I am doing yet. I'm in no position to hire anybody. But it made me realize actually that what people see, on the web or that you present is not necessarily how things actually are, right? And nobody wants to kind of say that, you don't necessarily have to kind of talk about all your vulnerabilities and challenges and difficulties like that, I think. That's not necessary, right? But you have to know them for yourself and understand that, have a plan in place to kind of get assistance when needed. And I have found that in starting a business myself, you realize that, how to better assist students that are starting a business, right? When I was just a professor, but when I hadn't had that experience, I used to teach, for example, how to incorporate a business for many years, right? But it's something quite different when you complete a certificate of incorporation and then you are now responsible for corporate taxes year end. There's a very different thing, right? That's not going to show up in your transcript, but the CRA is going to really care if you don't do that. So yeah, those are my kind of yeah. Hopefully that's helpful for people, and I don't necessarily want to depress people in that sense. But what's really important is that you have to have a really accurate understanding of yourself and the business that you are trying to build. I think both have helped me actually develop myself and help other people with that too.
True, true. I totally agree with you, Rajan, because even when you start a business and that is what the passion is, I think whatever struggles come in, probably you have to be consistent. So you have to, progress. So at least not now, but maybe in the future, you can see the results. So I totally agree with that. And once again, thank you very much for your time, Rajan. It was great having you in the show. And this is the end of the podcast. And thank you very much, Rajan.